So, dear clients and colleagues, thank you to each and every one of you for being here with us today. It is my pleasure. I can see among participants our old clients who already successfully obtained a construction license with us in some of our jurisdictions. It is my pleasure to welcome you at today's online conference, Access to the Construction Market of the GRATA operating countries. In accordance with the conference agenda, we aim to consider and discuss some legal challenges that construction companies face in Belarus, Kazakhstan, Moldova, Mongolia, and Turkey. Participation in the conference, it's not only a unique opportunity to gain new knowledge or structure the existing ones, but an opportunity to live communication with our leading GRATA international lawyers. Please feel free to ask any questions that may arise at any point during the conference in a question and answers box. Our lawyers will be happy to address your question during Q&A session at the end of the conference at 1 p.m. Moscow time. And I sincerely hope that you will enjoy today's conference and wish you all a productive and successful session. Many thanks for participation. And without further ado, I would like to begin with the first topic of today's session with regards to Kazakhstan construction license for EPC contracts of foreign contractors. Let me share the screen with you. Before we start, let me introduce myself. I'm a partner of Kazakhstan office and a head of our China office. So generally speaking, I'm responsible for all Chinese clients' activities in GRATA operating countries, which we talk today. And I have more than 20 years of experience, qualified Kazakh advocate, bar qualified. I did my master here in Beijing University, and I'm certified FIDIC lawyer. Since all of our, most of our foreign clients performing activities, construction activities in Kazakhstan work on FIDIC-based contracts. We do have pretty much a successful experience on obtaining construction license for foreign clients. We will talk about construction permits not only for foreign companies, but with the main focus of foreign companies planning to make activities in Kazakhstan. So this is all recommendation letters, letters of thanks of our clients who successfully obtained their construction licenses, mostly first category in the Republic of Kazakhstan. So, as I said, we will focus on foreign construction companies doing business in Kazakhstan. So the case might be that construction company plans to conclude the EPC contract for the construction in the territory of Kazakhstan. And this foreign company assumed that it would only perform engineering and procurement part. As for construction part, these companies, most of our clients, is planning to transfer subcontract to local construction companies in Kazakhstan. And most of our clients believe that in that case, they no need to obtain any construction license in Kazakhstan. If you are aware whether it's true or not, please feel free to put your answers in Q&A box. So the first question will be, is there any need for construction license in Kazakhstan? If construction company, foreign construction company as a party to EPC does not plan to implement any construction work in Kazakhstan and only going to be responsible for engineering and procurement. That might be a first question we will address. We also talk about, can the construction license of a foreign country be used directly in Kazakhstan? Which countries' construction license are recognized in Kazakhstan, and whether is that so? What volume of construction work can be subcontracted? Is it necessary to establish, for example, subsidiary, branch, or rep office in Kazakhstan in order to obtain construction license? And does the branch or construction company headquarter should apply for the license? So first question, as I said, is there a need for construction license in Kazakhstan if we are planning only to perform engineering and procurement and planning to subcontract 100% of work to Kazakhstani construction companies with local license? The answer is yes, you need to obtain Kazakhstani construction license, and you are a foreign construction company who are planning to sign EPC as a general contractor are not entitled to subcontract 100% of the work to the local construction companies. There is a direct restriction on our architectural, town planning, and construction activity law of Kazakhstan that general contractor should specify the type and scope of work that he's going to subcontract, and no subcontracting of more than 2/3 of contracted value is permitted. So generally speaking, 1/3 of the construction work should be performed by general contractor, and it is not allowed to subcontract it. And if you are planning to perform 1/3 of construction work, then you will definitely require construction license. There are some misunderstanding among some, theoretical legal advisor who said that according to the law, it is only related to contract works or contract price. So generally speaking, if engineering and procurement exceeds 1/3 of contract price, then it's okay. Then you're still entitled to sign EPC contract as a general contractor. It is misunderstanding. It is a huge misunderstanding. These contracts, if foreign contractors will sign those contracts as a general contractor, according to the civil code, this contract should be considered as a null and invalid. In most of the cases, they never even has been signed because during the procurement tender phase, bid phase, those foreign contractors who did not attach their construction license, Kazakhstani construction license, considered as not meeting qualification requirements for a bid and simply are not allowed to attend those bids. And we have a case when a client decided that it's actually possible, and then his bid documentation were rejected by the one of the banks, because most of these infrastructural projects are financed by EBRD, ADB, Asia Development Bank, or World Development Bank. And they do have a clear requirements on those, or in some cases it is financed by Kazakhstani government, and then procurement rules apply again. So the next question will be, can the construction license of foreign country be used directly? In fact, we do have some mutual recognition agreements, international agreements on mutual recognition of construction licenses between CIS members. We do have agreement between government of Russia and Kazakhstan, bilateral agreement between government of Kazakhstan and Kyrgyzstan. However, there is no separate rule for recognition of those licenses. So generally speaking, whenever you are planning to recognize the licenses of CIS member states, you apply to the same rules as general application for the construction license. So you still need to meet qualification requirements and apply the same documents. And it's worth to mention that, for example, if you are planning, for example, China don't have this bilateral agreement with Kazakhstan on recognition of construction licenses. However, construction experience of Chinese companies is still recognized as a foreign construction company experience in order to apply to the construction license in Kazakhstan. Let's talk about the categories of construction license. Construction license in Kazakhstan divided into 3 categories. First category is the highest one. So in order to apply for the first category, construction company needs to have 10 years of construction experience. Second category, it's a complex and non-complex object. It requires 5 years of construction experience. And the construction companies without any experience might only apply for the third category for the very limited type of objects and may have no experience at all. Except experience, qualification requirements includes engineers, production base, material and technical capacity, construction experience, which should be proved by construction license in a home country, in the country of incorporation, and realized construction objects. Let's talk in details of those requirements. First of all, it's an engineers. So this engineer should be certified in Kazakhstan. One engineer for each subtype of construction activity. And all of those engineers should work on a permanent basis. It should be chief engineer, chief of production, section foreman, operator, and so on. So what our clients was asking, foreign clients was asking, it's like, okay, Corinne, we are not going to start construction activity right now. And you want us to have 10 engineers in Kazakhstan. And from the moment of the attending to the bid to the moment of the real implementation of project may take time, like 1 year, 1.5 years. And construction companies don't want to have more than like 9 to 10 engineers in Kazakhstan and pay their salaries for nothing. However, this is a qualification requirements. And the question of my client was, may I apply my existing engineers, like who actually work in headquarters as a confirmation that I'm meeting qualification requirements? Generally speaking, yes, there is no any restriction for foreign engineers. However, these foreign engineers should be certified in Kazakhstan. But in order to be certified in Kazakhstan, you need to pass the exam. Language of exam is Russian or Kazakh. So for foreign engineers, in order to apply for certification in Kazakhstan, they need to sit the exam in Russian or Kazakhstan. So in our practice, we don't have those. Mostly it's all local engineers, certified engineers, and database is very clear. And the other option which was suggested by our clients, for example, sometimes, okay, I have a partner in Kazakhstan, and this partner has an engineers, and may these engineers work simultaneously in those construction company in Kazakhstan and in our construction company in order to apply for the license? And the answer is negative again. So it is not allowed for engineers to work simultaneously at 2 places when you are applying to the construction license. It is quite, there is a publicly available list of engineers which maintained by state authority. I will show you how it looks like. So you can see the name of the employers of the engineer, his identification number, like tax number, his certificate number and date of issue of his certificate. Next is the working place of the engineer, and the last column is who actually give him this certificate. So once the person works for this, for example, Centex Group, he cannot apply as an engineer to another company and claim, and that company cannot claim that he has this engineer to meet qualification requirements. And this is absolutely, publicly available, transparent list of engineers. So no chance to have engineers in 2 companies simultaneously. Next qualification requirements is the production-based. Here it was to mention that for the first category, production base should be on the ownership. Plus, additionally, foreign company requires to lease a production base in Kazakhstan. For the second and third category, it is enough just to have a production base on a lease in Kazakhstan. The procedure became quite complicated starting from 2019. According to the last amendments, production-based period should be at least 1 year. Whenever lease exceeds 1 year, then state registration of lease agreement required. Seems quite easy, nothing kind of special. However, in practice, our clients meet lots of obstacles for this state registration of lease of production base. It every time might be difficult, different circumstances. For example, we were planning to lease a production agreement of one limited liability company in Kazakhstan. And at the moment of the registration, we find out that this production base belongs not to the limited liability company, but to the shareholder of the limited liability company. So it was the reason for state authorities to reject registration. And the next stage should be that we either sign the lease agreement with the owner, physical person, with the shareholder of this company. However, in order to do so, this shareholder needs to special tax registration as an individual entrepreneur and pay taxes. He said, I was like, okay, I'm not going to do that. And another option was to transfer this production base as an input into the charter capital of the LLC, and then in that case, LLC will be able to sign the production base. It ended up that after 2 months of negotiations, the owner of the production base simply said, oh my God, it's so much trouble with this lease agreement, I'd rather not to lease my production base. The next owner of the production base, our client found, at the moment of the registration, we find out that there is some mistakes on the registration of the land of production base. So when they apply for the registration of the production base lease agreement, they find out that actually the land documents have some issues, and the owner of the production base need to make some amendments in the land documents, land certificate. It was also quite troublesome for them, and we cannot apply on behalf of the owner. It should be done only by the owner, not by the applicant of the lease agreement. It is also needs, so it is very time consuming. For the last of our clients, he actually was trying, and we were trying our best to help him. This is not legal advice, but we understand that foreign companies are not familiar with the market, and our like lawyers were helping them to look through this list of available production base for lease and everything. And it took us 6 months just to find the right production base. About a production base on the ownership in the country of incorporation. So sometimes our clients is a huge enterprises, construction enterprises, and the holding companies, for example, based in Beijing, has a huge numbers of employees, like 7,000, 5,000 employees, and they were all working in an office building here, which is like 20 floors office building, which belongs to this construction company. However, and they apply saying that, okay, we have a production based on an ownership in China. This is our documents confirming that. This is not the case. It should be a industrial building. It should not be just office buildings. It should be garage for machines and equipment. It should be warehouses. So it rather but choose this small production base in somewhere around the world, which is on your own ownership, not your subsidiary ownership, not your like mother company ownership. It should be applicant ownership with warehouses, garages, like all industrial buildings, and plus workspaces. And for the least construction-based production base in Kazakhstan, it should be state authorities on-site inspection, and all employees, all equipment should be on a least production base by the moment of site inspection. As per production base in a country of incorporation, we attach photographs of production base, and it should be a address. We make a photo of the address on the plate, you know, with that actually the documents, address specified in the documents match with the photos of this production base, and there is garage, warehouses on it. And so we attach all of these photos to our application in Kazakhstan. About material and technical capacity, it should be owned or leased in Kazakhstan. So generally speaking, we are not applying any documents of ownership in a country of incorporation. We only apply all those leased equipment, materials, and in Kazakhstan. There is a trick here that there is no, a full list of required material and technical. It is written according to the law that it is minimum equipment which is compulsory for that subtype of activities, of construction activities in Kazakhstan. And then state authorities decide by themselves which equipment they need for construction of road, for example, which equipment they need for construction of railroad. And we had a case, this is the next case, when our clients need a subtitle of activities as the construction of tunnels in order to participate in the bid of underground metro construction in one of the cities in Kazakhstan. So the qualification requirement of state authority was that the minimum equipment is this machine which make tunnels. Then our client said that this machine is not ready-made machine. It should be produced according to the technical requirements, according to the design, based on the size of the tunnel, especially for that particular project, and it cannot be produced. It is not like machine which you just buy and you have it in order to make tunnels. This machine produced for specific tunnels for specific projects. And in that case, we provided the ownership documents of this machine, which our Chinese clients used in Russia. And that was sufficient for our state authorities to confirm that actually, yes, this company has a capacity to contract, to perform activities on tunnel construction or underground construction in Kazakhstan. So actually it is always very important to keep close, connection and always ask state authorities on progress. It is allowed to do so and to give a reasonable explanation. Next one is the construction experience. In Kazakhstan, construction experience should be continuing without any interruption, without any time gaps in between them. Why? Construction license in Kazakhstan given without expiration date. If for any reason your construction license has been terminated or suspended or whatever, interrupted, it means you had construction issues. And that was your penalty. And starting from that moment, your construction experience starts to calculate from the very beginning, from as you have never had experience in construction. Of course, not all countries are the same. However, the Kazakhstan requirements is that it should be continuing construction license in the country of incorporation for the last 10 years, for example, for the first category construction license. And it is very important for applicants to prepare all construction license for the last 10 years. We had a case when our client, because in China, for example, they renew construction license every 3 years, and not only every 3 years, but for example, if the CEO of construction company changed, if additional subtitles of construction activities. In Kazakhstan, main construction license will not change. You just change the attachments to the construction license, and still the date of issue will remain the same. However, not like in all countries is like that. And then we find out that we only have the construction license copies, like previous construction license copies for the last 8 years. However, we need to prepare all construction license for 10 years. And it was quite an issue to find out all of those construction license. It was another issue to notarize them because state notary refused to notarize a copy of non-existing documents, like just a copy. So we find out a way as a solution, we just notarize that the translation is correct. And that was okay with, that was accepted by our state authorities. So please make sure that you prepare your construction licenses for 10 years. And it should not be a gap. If any gaps, then it is not applicable. So we did have another case when we have a gap between old license and new license, 1 month, it's fine here. But it's not fine according to the Kazakhstan regulation. So what we have done then, we applied this Chinese company construction license, which they got in Belarus. So for that particular gap, they had another license ongoing. And then we claim that we still have continuing construction experience without any gaps. So for last requirement, which is realized construction objects, it should be, for the first category construction license, it should be 10 objects as a general contractor, 20 objects as a subcontractor. For the second category, 5 objects as a general contractor, 10 objects as a subcontractor. It is again very important. For example, in any country, once you finish the construction work, you just sign taking over certificate. However, according to Kazakhstan regulation, if you work as a general contractor, you sign one act of object placement into operation, which proves that you work as a general contractor. If it's just act of work completed, it means that you work as a subcontractor. It is the understanding. It is according to the Kazakhstani law. Nothing to do with foreign law, right? But when translation agencies translate your taking over certificate into Russian and notarize, legalize them, all these troubles with notarization, one should make clearly check if it's translated as an act of object placement into operation. Only these documents will be considered as the contractor worked as a general contractor. If, for example, the translation is wrong and taking over certificate translated as an act of work completed, then you need 220 of those acts of work completed because state authorities of Kazakhstan will consider you as a subcontractor. If you still need to prove that you work as a general contractor, then EPC-contracts should be translated, notarized, and provided to the state authorities to prove that one works as a general contractor. It is pretty much time-consuming and also not. It is also quite expensive because EPC contracts, we all know, are quite huge in volume. So I will not talk too much about the documents required. Just please pay attention if your country of incorporation is a part of Hague Convention, then documents should be apostilled, which is quite a simple procedure. If the country is not Hague Convention, then documents should be legalized. For example, our Hong Kongese construction companies, they only need to apostille their documents in Hong Kong. But Chinese clients, they need to legalize the documents, and minimum time frame for legalization of the documents is 2 months. So it's very important to prepare the documents in a very correct way, right? Taking over certificates in Russian, instead of act of work completed and so on, because otherwise to prepare the new documents which take 2 more months. And in order to apply, we apply all documents online in an eGov database e-license in Kazakhstan. And in order to apply online, headquarters of foreign construction company requires to obtain the business identification number in Kazakhstan, and based on business identification number, we got the electronic signature. And based on that electronic signature, we apply for the license. Next question is whether we can, foreign construction company can open a subsidiary in Kazakhstan, set up a subsidiary, and then this subsidiary apply for Kazakhstani license. The answer is negative. Subsidiary will be considered as a newly established legal entity without experience, without construction experience, and mother company experience cannot be considered as a experience of subsidiary. So the only way to apply for the license is to establish branch, because branch, according to the civil code, is just a subdivision of legal entity and is not a legal entity. And a branch performs transaction on behalf of legal entity. So make sure that branch apply for the construction license on behalf of headquarter, on behalf of construction company headquarter in the country of incorporation. Why this is so important? For example, I'm head of our Chinese office, so I'm trying to monitor and track all these construction licenses of Chinese companies in Kazakhstan, which mostly has been obtained by us, but some of the companies not apply through our law firm, but independently. And we can see here that the status, and it's again publicly available information, the list of construction licenses you can find on the e-government database. The list is publicly available and maintained by state authorities. So here you can see the construction license for third category, valid, valid, valid. It's all Chinese companies. And here we can see terminated, invalid, invalid, terminated, invalid. Why? Then we have a look, pay attention that construction license were applied on behalf of the branch of China something company, like China National Company. And then for the project activity, again, applied on behalf of the branch. Then somehow they might apply again, and again this construction license were decided as an invalid. And then from the third time, we can see that this time the company already applied on behalf of the headquarter, and this construction license is valid. So in order, to avoid all type of this sort of difficulties, you'd rather apply correctly on behalf of headquarter. Another very important thing here might be that we have a case when back to 2019, there was amendments to the foreign exchange control law when branches of the foreign companies were decided as the residents of Republic of Kazakhstan. Transaction between two residents currency of transaction might be only national currency Kazakhstani tenge. Only if it's a transaction between non-resident and resident of Kazakhstan can be made in foreign currency, which was US dollars. And one of the party of contract said that they need to change the EPC contract and specify the currency of the contract, EPC contract, as a national currency Kazakhstani tenge, which was not good for our clients because a fluctuation rate of tenge is quite high. Then we claim as a legal advisor that this deal is between headquarter, which is non-resident of Kazakhstan, and Kazakhstani company as an employee, and contracts with non-residents can be signed in US dollars. However, due to these amendments, they said the contract signed by a branch and branches should be considered as a residence. Then we apply to the state authorities for confirmation, which is National Bank of Kazakhstan, and get confirmation that it is allowed actually to keep this contract in USD. And because and our main argument was that the license was obtained by headquarters of this company, and headquarter is a non-resident, and branches only signing the EPC contract on behalf of headquarter. And since it is not legal entity, it is non-resident contract, and USD currency is still applicable. So these small things like under the branch name or under the headquarter name may lead to the huge consequences for the project. So this is a list of main regulatory framework. Whenever you have some questions, you can find out, like, for example, if you have a question with what is actually qualification requirements, please refer to Order 136. What is differences between first, third, and third category complex objects, then it's Order 165, and type of works, a subtitle of works, it is Order 231. Thank you very much for your attention. And if you have questions, please feel free to write them on the question and answers box. And that's all for Kazakhstan. Please welcome Haretskaya, who is a junior associate of our GRATA Belarus office, who will be speaking to us on obtaining permission to carry out construction activities in Belarus by foreign contractors. Angelia, the floor is yours.
Thank you, Gulnur. My name is Anhelina Haretskaya, and I'm a junior associate of Belarusian office of GRATA International. Today I'll tell you a little bit about how foreign organization may enter construction market of Belarus. First of all, I think that we should begin with the fact that all subjects in construction are divided into 5 classes of complexity. To carry out objects of the first to fourth classes of complexity, organizations need to meet height requirements, while the 5th class includes simple subjects, during the construction of which special requirements are not imposed on organization. The assignment of objects to the first to fourth classes of complexity is carried out by the customer, the developer, together with the developer of pre-designed documentation or design documentation, or in each specific case. To determine the class of complexity, you need to refer to the state standard of the Republic of Belarus. For example, on the slide, you may see which objects correspond to a certain class of complexity. For example, high-rise buildings, subway structures belong to the first class of complexity. To the second class belong such objects as buildings and structures with spans over 36 to 100 meters, oil and gas wells, and so on. To the third class belong such objects as buildings of retail facilities with a trading area of over 1,000 to 5,000 square miles, building to preschool education institutions with a capacity of over 15 places. Commercial buildings with a retail area of up to 1,000 square miles belong to the 4th class, and to the 5th class belong such objects like buildings and structures that cannot be classified as 4th class complexity, and construction for seasonal purposes, sheds, fences, and so on. Today, the legislation does not establish special requirements for foreign organizations operating in the field of architecture and construction on the territory of Belarus. To admit a general contractor to the construction market of the Republic of Belarus, it is necessary to go through the same procedures as for Belarusian companies, with some exceptions. In order to carry out certain types of construction activities, as well as work on the inspection of buildings and structures, legal entities must have an attestation issued in accordance with the established procedure. The types of activities for the implementation of which it is necessary to obtain an attestation are fixed in the list. The category of the attestation depends on the complexity of the objects planned for construction, as well as an organization's compliance with the requirements for the category of the attestation. On the slide, you may see that attestation is not obligatory in some cases. For example, during the construction of object of the 5th class of complexity, when performance of works on installation technological equipment, as well as if the organization is a general contractor for the construction of facilities of the 5th to 1st classes of complexity with a construction cost less than 5,000 base value. It's about 55,000 United States dollars. As for the requirements for attestation, depending on the type of work and category of the attestation, the following requirements are put forward. First group is requirements for work experience. One important thing is that only realized objects are included in the experience. That is, if the objects have passed the state examination, if it's mandatory, and were put into operation. The second group of requirements is requirements for the head of the organization to his education and his experience, and requirements for the staff. It's important that the staff work at the main place of work. Also, there are requirements for their education and work experience in the sphere of the attestation. First group is availability of quality management system, availability of fixed assets. The sixth group is means for measurement and control. Occupational safety management systems. The 8th group is availability of certain licensed software. And the next group is the presence of an archive of documentation. To submit documents for certification of a legal entity, an organization must leave an electronic application on the website. Payment is made after submission of documents. There are two options to ensure the availability of specialists for a foreign construction organization. Option one is to send foreign specialists for attestation to Belstrade Center. It's a governmental body, governmental organization that is responsible for attestation. And these foreign specialists should have an education that is appropriate in accordance with the admission criteria for passing attestation, and also should have work experience in the attestation specialization. As a rule, this is a workbook. At the same time, in the European Union countries, Turkey, Israel, work experience is confirmed by letters of recommendation for employers. That's why you may have any of the proposed documents to show that the specialist has appropriate experience in the attestation specialization. Option two is to hire Belarusian certified specialists or specialists with the necessary education and work experience and send them for attestation. The list of employees who should pass Attestation includes 148 positions depending on the type of activity. Each position has specific education and work experience requirement. Attestation takes place as follows. First step is registration on the website. It is possible both by an organization that sent a specialist for attestation or by a specialist himself. Preparation of a package of documents, provision of these documents, setting the date of the qualifying exam, and then passing the exam on the appointed date. The set of documents, as you may see on the slide, includes application, 2 photographs of a specialist, copies of his diploma, copies of the diploma supplement, copy of the workbook or another document that shows specialist's experience in attestation specialization. If the documents are submitted by organizations that send specialists for attestation, also you should send a cover letter. There is an example of this document on the website, and also specialist should have with him passport or other identity document. The cost of attestation per one person, including VAT, is about 28 United States dollars. The payment is made, of course, in Belarusian rubles. The qualification exam is conducted in the form of computer testing, and it lasts for 16 minutes. Also, there is a possibility for a foreign specialist who doesn't speak Russian to take a qualification exam with the assistance of an interpreter. Currently, the following types of work in construction are subject to mandatory certification. So that means that apart from attestation for an organization and attestation for specialists, some objects in construction are subject to mandatory certification. Examples of those subjects you may see on the slide is, of course, construction work performed during the construction, reconstruction, overhaul, restoration of buildings and structures of the first to first class of complexity, execution of works on filling window and door openings, execution of works on the device of anti-corrosion coating of building structures, and others. Certification of work performance includes the following stages. First of all, submission of an application and attached documents. The set of these documents depend on the assessment scheme which was chosen for certification. Analysis of the application by the certification body, identification of work performed by the applicant, then assessment of skills and qualification of personnel, assessment of the stability of the work execution process. It is carried out on the basis of the documents that were provided. Issuance of a certificate. So there is a possibility for foreign organizations as well as for newly created organization, Belarusian organization, which don't have appropriate experience in construction fields. If they cannot confirm their experience, they may obtain certificates for a period of 1 year. In such a case, the certification body may decide to conduct a sample assessment. During the year, the holder of the certificate of conformity must ensure the quality control of the work performed by him for which the certificate were issued. In case of confirmation of the quality of the work performed, the validity of certificate is extended to 5 years. In case the quality of the work for which the certificate of conformity was issued is not confirmed, the certificate of conformity expires after 1 year. So that's all I briefly said for today. Thank you for your attention, and you are welcome to write down your question in a question and answer box, as well as personally by mail you may see on the slide. Thank you.
Anhelina, many thanks for your presentation and contribution. I will pass the floor to our next presenter, Yanjmaa Bumtsend, an associate of our GRATA Mongolia office. And she will speak on construction activities in Mongolia.
Hello, good evening, everyone. And I am Yanjmaa from GRATA International Mongolia. Today's my topic is admission of construction companies to operate in Mongolia. Okay. And according to National Statistic Office of Mongolia, and the most investor has invested in mining sector around 48.6%, and only 6.9% investor has been invested in construction sector in Mongolia. And also this investment percentage in the construction sector was decreased by 1.4% compared to previous year. And then this survey was conducted by World Bank in 2019, and in Mongolia ranked 29th with 78.2% in terms of construction permits. And this survey showed that there are 17 procedures, and it is shown that it is spent around 4 and 5 months to obtain a construction permit. And also building quality control and index was ranked as a excellent. As for regulation of Mongolia, regulation related to construction activities, production of construction material, construction work, and its supervision and commissioning is regulated by law on construction. And also construction activities shall be carried out on the basis of their license, construction work permit, and their registration. And first of all, a license. Building and structure belonging to low, medium, high, and special complexity shall be carried out by a legal entity with a license. Then to design building and structure, to perform construction work and building and structure, to engage production, assembly, maintenance, and service of the building facilities and its parts, and then to produce the design design structure items and materials of the load capacity, and it is raw material, flammable and toxic and energy efficient products shall be performed on the basis of the license. Also, in addition, applying for the construction license, the legal entity prepare information on specialists and production premises list and description of the equipment and probability conclusion made on the design of building and structure. According to law on construction, the license is issued for a period of 5 years, and it is also extended in another for 5 years. And a license holder must annually submit the operational information and report to the state administrative body in charge of administrative construction matters. And then a license is not issued to a legal entity with not registered and incorporated according to legislation of the Mongolia, and also permanent establishment shall be depended on it. In another word, that the permanent establishment cannot issue any licenses in Mongolia. And then if the license holder has violated the legal requirement or has not engaged activities specified in the license for consequent 3 years, firstly, the license shall be nullified, and then it shall be announced to public openly. And secondly, construction work permit. However, all legal entity has a license, but they should obtain a construction work permit to start the construction work. And in accordance with construction law, it is prohibited to start construction activities without any proper construction work permit. Yes, so construction work permit means a decision made by a competent authority to allow construction work to be performed in accordance with law. And construction work permits are issued by government or governor of the province in capital. First, government is issued construction work permit on nuclear and thermal power plants, hydropower plants, and subway, airport, railway, transnational oil and gas guideline, and crude oil pipelines. And as per governor of the province and capital, they are issued the construction work permit, except for permit to be issued by the government. And then construction work permits are issued to build a new building or structure, to expand and renovate building and structure, and finally to demolish building and structures. To applying the construction work permits, the license holder shall submit the following documents to the government or governor of the province and capital, such as a first request decision confirming the location, design, and technical condition of the building, complete design, introduction of the design legal entity and its state registration certificate, and assessment report of building, and certificate of accident and liability insurance, license of the construction contractor, plan on how to implement, monitor during the construction phase. As per period of the construction work permit, the government or governor of the province and capital shall resolve the construction work permit within 10 working days after receiving the request of legal entity. And if the government or governor of the province and capital refuses to issue the construction work permit, they shall provide a reasonable explanation in writing to the legal entity which requested. And also, moreover, if the legal entity is considered that a reasonable explanation issued by a competent authority is unclear and doubtful, and they have a right to claim to the court. And secondly, construction work permits shall be issued for the period specified in the design. And then if the construction work is not completed the period specified, the legal entity may submit an application for extension 30 days prior to the expiration of the permit to the government or governor of the province and capital. Also, to change the information specified in the construction work permit certificate, to change the contractor, client, and organization to implement author's control, to expire the term of the contractor's license, to change in the design, and to put the unfinished building and structure in protection mode and expire the term of the construction work permit, the legal entity must notify about it to the competent authority who authorized the construction work permit. And in addition, if there are changes in the basis structure of the building and the size and capacity of the engineering network, design shall be redrafted, and also a legal entity must obtain a new construction work permits according to the legislation of Mongolia. And the legal entity submitted the incomplete and false information, or the document did not meet the requirements of the relevant legislation, obviously competent authority will refuse to issue the construction work permit and license. And as for liability, it is prohibited to start construction activities without a proper construction work permits. And also, if the legal entity violated the law on construction and other related regulations, they shall be liable under the offense law and criminal code of the Mongolia. And in case the failure to obtain a construction work permit or license, the caused damage or loss shall be paid by default person, and a person shall be fined in accordance with the offense law of Mongolia. And finally, we analyzed some court decision related to construction. Most of the time, court decided the following decision: first, to annul the construction work permit and license; second, to revoke the decision on suspension of the construction work permit and license, and third, to revoke the decision on refusal from the extension of the construction work permit and license. And the claimants to annul the construction work permit and license are often filed by individual or legal entity whose their rights have been violated. And as for second and third, claimant other than second and third are filed by a legal entity with a license against to government agency. And thank you for your attention.
And thank you very much. Please welcome our partner of our senior partner of our GRATA Turkey, who will be examining common legal challenges construction companies face in Turkey. Ali, the floor is all yours.
Thank you, Gulnur. Oh, hello everybody, and thank you for joining us today. My presentation is about the challenges that foreign construction companies may face in Turkey. And I'm gonna try to make this as simple as possible. So I'm gonna just pass these introduction parts, so I'll start with what kind of entities a foreign company can be present in Turkey who would like to do construction business. The main two ways is, which is a very, I believe, a classical approach for all the jurisdictions, is establishing a company. There are two types of companies in Turkey which you can establish, which one is a limited company, one is a joint stock company, as we call, and which is called incorporation in some other jurisdictions. Each company have its own advantages and different rules underlying it, but I'm not going to go into that details today. And the other way is establishing a branch. Branch is directly managed by the foreign entity, foreign company who has the branch in Turkey, and the foreign entity appoints a general manager to that branch and allocates a certain amount of capital to be used for the operations of the branch. Branches, I would say, is a good way to start if you are entering the Turkish market for, let's say, one specific project, because the closing is easier after the project is finished. You don't need to enter into not very long, but at least 8 to 12 month liquidation periods. You don't need that if you have a branch. Closing it easy, and it's very like a company. The taxation of the branch is just like a Turkish company. The major advantages, as I said, other than the liquidation process, is it can be established for some specific project. If you don't want to stay in the market, we generally recommend our clients to set up a branch. There are a few exceptions, but this is very limited, which you can attend tenders. Generally you cannot land in a foreign company name and build something on it. You cannot do that. Only some government tenders, and if the tender specifications allow it, which is generally for those big infrastructure projects, you know, like the foreign company can come to Turkey, but with a consortium. If you have, or a joint venture that you're going to have with Turkish local partners, you may not need to be present with a legal entity in Turkey. But in practice, all companies, foreign companies which attend these kind of big tenders, infrastructure tenders, they generally tend to set up at least a branch because, you know, even though on the paper legally you don't need an entity, but you know, you will have people here and you will need some management, daily operation issues. So generally this exception is not much preferred by the foreign companies, even though it is allowed in some exceptional cases. Very briefly, other than private entrepreneurship, which I mean is coming here, setting up a company, and, you know, buying a land, developing a real estate project, you know, generally, as I mentioned in the beginning, you will need a company in Turkey for that. But for other kind of infrastructure projects, BOTs, PPPs, this is, you know, until early 80s, Turkey did not have that kind of approach. Everything was frankly built mostly by the state itself. But after the liberalization of Turkish economy, as I said in early 80s, these BOT projects and PPP project structures were being introduced into the legal system. As we mentioned some examples which you may heard of if you are following up Turkey, the Niğde airport, the Eurasian tunnel, the nuclear plant which Russia and Turkey are developing jointly, the third bridge, we call it third Bosphorus bridge. These are all made by PPP structures. And since we are now in a new system, now we have our own presidential system. You know, Turkey was a parliamentary system before, but after, by 2018, we have now a presidential system, which is kind of unique to Turkey. So the president president has full power, but that full power, that may be subject to criticism because of the powers, but that also helps to pass the laws very fast, you know. So that's why we're going to see in the next slides, upcoming slides, the related laws about a specific project can be very, rapidly passed by the president himself. For instance, I also mentioned some different sectors, construction examples here for you. As you see, this is a thermal plant, also regulated under its own, separate law. Airport, also it has its own, another law for this airport construction. This airport system is the construction joint venture is spending the money, building the construction, and the government provides certain passenger guarantees. And in exchange for that, the consortium pays annual lease rental fee to the government. So the government gets a rental fee, but if the minimum passenger guarantee is not met, and because of the COVID now, none of the airports, I believe, in Turkey meet such criteria, we as the taxpayers should pay the difference to the consortium. So it's a kind of, with this specific minimum guarantee projects, it may be interesting for foreign clients because it's a guaranteed structure. And besides the financing, the Treasury provides relevant guarantees for such consortiums to obtain financing from abroad. That also applies, these PPPs, the BOT system also applies for dams, waterworks, tollways, bridges, in any kind of, you can consider like this, any kind of infrastructure project. We have this kind of separate laws applicable to each project. Of course, we have general framework laws, but also we have these in particular to the project laws and regulations. This is also military construction. That's not generally open to foreigners, but it's also given to private constructors. So we just put it here, but because of the security issues and national security issues, these are not open to foreign constructors. So the main subject of my presentation is the challenges you may face. So I'm going to start with the private investment approach. I'm going to start with private investment. So you set up your company in Turkey, a construction real estate development company, and you want to develop a project and make your profit over the sales of your project. The issue starts with the land. When you buy a land, the land in the preferred way is the land in all the lands have its zoning rules. When I say zoning, for a specific land, can be allocated by the municipalities. For instance, if certain land can be allocated for residential purposes, certain areas can be allocated for commercial purposes, sometimes mixed-use purposes. So when you buy a land, your goal, your project, let's say, to construct on such a land should match with the zoning of the land. But the problem here comes with, there are not many lands, especially in big cities. In small cities, in Anatolia, this is not that common challenge. But for instance, cities like Istanbul, finding a land is very difficult. So the land supply is very limited. And you found a land, even though it doesn't meet your criteria for your project, you can still buy it. And then you need to apply to the municipality to change the zoning in accordance with your project. So I would say this is the one of the challenges about real estate development, because as I said, you need to deal with an administration, which is municipality, and municipalities may be sometimes, demanding. When I say demanding, I don't mean like corruption or bribery things, don't get me wrong, but in practice, sometimes, municipalities, first, they can require you, okay, we're going to change the zoning in accordance with what you request, but I'm just making up this, okay, you're going to build a school to that area. You're going to build a, kids park here. You may face this kind of request. It's common, So I would say changing the zoning of the land in accordance with your need, it may be an administrative challenge. This is more applicable for the financial issues. Financial challenges is more, this is generally applicable for tenders or even private deals. Sometimes we have a structure that you buy a land and you share the profit with the landowner, okay? Because the landowner doesn't have financial means to develop, let's say, his or her own land on her land. So what you do as a contractor, you make a deal with the landlord, and there will be a number of apartments to be built, let's say, and you have a sharing system. So let's say you have 100 apartments to sell. The landowner gets 20 of it. As the contractor, you get 8 of it. First, we call it revenue sharing system. And in that kind of private deals, and including the government tenders, you are generally requested to submit a performance bond, which will be a letter of guarantee. The foreign, newly established foreign, Turkish entities with foreign shareholders will have this problem, may have this problem with the banks. Because you may not, let's say you set up your company in Turkey in 2021 here, but your company does not have a background. Your company does not have an experience and credential. Your company does not have a financial background. So Turkish banks would not prefer to give you a bank guarantee. So what you need to go to your own bank where your main jurisdiction is, and get a back-to-back guarantee from your bank to Turkish bank. So this may increase, not big, but this may increase your financial expenses to get a letter of guarantee, and may create more procedures to obtain such a guarantee. And as you may know, inflation is another issue in Turkey. For instance, the latest numbers declared is around 14%. And when you are making your project feasibility studies, inflation is something important that needs to be considered by an investor. And another thing, because of the cost, especially when it's construction, the currency rate fluctuation may be sometimes, not all the time, but at least for the last year, we can say that for the last 2 years, may be very crucial for you. Because, for instance, the Turkish currency lost 40% in value against dollar in the last 2 years, which, considering that the cost of a construction is dependent on USD rate, that would mean such a depreciation of Turkish lira against US dollars would mean that your cost is increased 40%, which I don't think any construction company is making 40% profit anyway. So that's something should be considered, and maybe hedging your risks in terms of the fluctuation rate risks may be considered. That's one of the, but that, I will be honest with you, that's a problem for the last 2 years, frankly. Before that, the rate was more stable, and this was not an issue to be considered as strong as today. But as of today, at least, and hopefully economy gets better and more stable, this may turn to be a simpler issue compared to today's issue. Okay, as lawyers, we also complain about this legal complexity, because Turkish lawmakers tend to regulate everything, almost every single item, with a separate regulation, which is making for any investor, but also lawyers, to follow up the regulations. And they're also, because we gave this tax regulations as an example here, as you will see, each tax is different with a different, each tax is regulated with a different regulation. And sometimes there are some discrepancies, there is a mismatch between two regulations, and what you need to do as a lawyer, either you wait this to be fixed by the lawmaker, or you follow up the court precedents, or you create your own precedent by going to the courts. So that's very important. What I would personally suggest to any investors who would like to consider entering into Turkish market, like, they need to follow up the regulations. And one of the things about, I said previously about the presidential system in Turkey now, I mean, practically, and sometimes it happens, not maybe very major points, but in practice it may happen. You go to your bed, and the next day morning, you may wake up with a new law, because of the president's power in that respect. Of course, they don't do that for big things, but just to give you the understanding, I want to mention that why it is important to follow up the regulations. employment of nationals, foreign nationals, because, you know, a foreign investor generally would prefer having its own people, at least some of his own people, to be present in its investment. You're going to need 5, you can employ 1 foreign national by employing 5 Turkish nationals, which is, I wouldn't consider this as a challenge that much, but it's something that you need to keep in mind. And there are some, because Turkey is getting a lot of applications, at least for residency and citizenship and residency, but as far as I know, more residence applications. It kind of takes more time than it was used to be. And there is this rule that once you apply, you cannot leave the country over 15 days. And if you want to leave the country, you need to get a permission. I don't want to make you scared. This is a simple procedure, but at step, you know, you need to apply, you get yours. I mean, when I say you, your employee who applied for a residency should go and get this permission to go out of the country and should come back in 15 days. And when it comes to, I'm sure that as, I mean, we are all, you know, eastern part of the world. We're all from eastern part of the world. But of course, the cultural differences, we always see this as an issue. You know, it's, I mean, as a lawyer, as a practicing lawyer for 18 years, you know, when you meet with a client from, it doesn't matter, but like even US, China, Russia, Kazakhstan, Saudi Arabia, Kuwait, the culture is always different. You can always find things in common. So getting used to the cultures in the beginning may be a challenge, but you know, if you want to be a long-term player in the market, you're going to get used to it. Language may be a problem because if you are a private investor, I mean, you're going to invest on your own. When you are investing in government tenders, I would say, language is not that problem because that high level of construction work, your counterparties in the government, your partners, local partners, whoever, they would of course have full English knowledge. But when you want to be a private investor, you may face with this language issue because, you know, Turkey people, I mean, it's getting more common, but I wouldn't say, you know, most of the people in Turkey would speak English, at least. And this is a small note that needs to be considered for those who would be present in Turkey and work here, for their employees. The school issues we believe is important. You need to look into that. You know, if you're sending your general managers from your own country to Turkey, of course, these kind of personal needs, humanitarian needs should be considered and should be taken into consideration. And as I said, these are the tax numbers. It was 20% until 2018. Now it's 22% now. And the government projects, I would like to mention that government projects generally are given certain exemptions. So if you want to enter into a government tender, you must look into it, especially when these are infrastructural, big projects. Government's approach to that is generally government always provides certain exemptions. So these should be assessed in every single case. One thing, I'm sorry, I forgot to mention about the financial challenges. You know, we have this saying in Turkey, you need to have a good doctors, you need to have a good lawyer, and you need to have a good financial advisors. Why I would say that is important, because if you have generating of your USD currency, I mean foreign currency, And the changes in the foreign currency in Turkey considered as profit. For instance, if you have $1,000, which is, I'm just going to make up the numbers, 14,000 TL, and in a month time, your $1,000 is now 16,000 Turkish TL. The difference of this 2,000 TL is considered as profit. So the government expects you to pay tax over it. Just, I forgot to mention that. So I just wanted to touch base very quickly. So that's why you really need a good financial advisor too. And for international, I mean, big projects, generally the dispute resolution mechanism is strong, I would say strong. And Turkey is a part of New York Convention. Turkey is a part of the World Bank International Center for Settlement of Investment Disputes, which we call as ICSID. And Turkey has many bilateral agreements with various countries and jurisdictions, these investment protection treaties. So at least if the worst case scenario, something bad happens to your investment from the government, I would say you are, as an investor, highly protected with this international recognition of the dispute resolution mechanisms. These days, finally, these challenges, I don't know how it sounded when I explained it, but we live in this world on a daily basis. So these are challenges, but these are challenges that can be resolved. These are challenges that have answers to it, solutions to it. And if I personally also think that these days are good days to invest in Turkey. The reason for that, because of this shaking of the economy for the last 2 years, now Turkey is kind of cheap compared to before, because, for instance, we are representing many private equity funds, and we are so busy because 2 years ago, they cannot even get an appointment from the CEO of a company. Today, they're buying that company. Or 2 years ago, they cannot buy the same company for $100 million. Today, they're buying the same company for $20 million. So that, at least those investors who generate mostly USD, Euro currencies, any foreign currency, but especially USD and Euro, I would say, it may be a good time to consider investing in Turkey, because, as I said, now making such investments are cheaper compared to before. Thank you for listening, and thank you for your time.
Ali, thank you very much for your excellent presentation. Indeed, I believe we all have the same challenges in all jurisdictions which are presented here today, which is like currency fluctuation rate, cultural differences, language barriers, and employment of foreign employers. So once again, thank you very much for your presentation. And I give the floor, and I give the floor to Yekaterina. Yekaterina will associate of our GRATA Moldova, and she will cover the admission of construction companies to operate in Moldova.
So let me present myself once again. My name is Yekaterina Cramarenko. I'm associate of GRATA Moldova. And today I will present you the admission of construction companies to operate in Moldova. I focused my presentation on the main stages for obtaining the construction permit, and we will track together the competent authorities, the timelines, and the costs incurred in connection with the obtaining of construction permit. The main law which regulates the permission of construction works, it is the law, Moldovan law on the permission of construction works. The requirements of this law are mandatory for obtaining the permit for construction of objects of any type, category, purpose, and type of property, with the exception of military and secret facilities for which a special permit is issued. As an example, I took the procedure of obtaining a construction permit for a warehouse, and we will track which licenses and permits are necessary in order to respect all the procedures and to receive all necessary inspections and obtaining utility connections. I named the construction company BuildCo. As I will mention the costs incurred, please keep in mind then that one United States dollar is approximately 18 Moldovan leys. You can see, we start with the first stage. You can see and compare the competent authority, timeline, and costs with your countries, and maybe you, I think we have some similarities regarding the procedure. So the first step is to obtain extract from the cadastre. Obtain extract from the cadastre with the cadastral plan of the land plot. This will be required for obtaining the city planning certificate. It takes 9 days, and it is about 51 Moldovan leys, so about $3. Next step is requesting and obtaining a city planning certificate itself. So the competent authority is General Direction on Architecture, Urbanism, and Land Relations. So here you have to prepare the documents established by the law. The time limit is 20 business days if the city planning documentation is available for this particular land plot, and 30 business days in case such a document does not exist. You can see the costs. The third step is obtaining geotechnical study, soil test. Here the competent authority is a private licensed company. The time to complete is 9 days. What for we need a soil test? A soil test is a necessary step for development of the project. The soil investigation helps to determine the bearing capacity of the land, which helps to determine the load capability, the type and depth of foundation, in order to make sure to select a suitable construction technique. So this is the aim, to be sure that we select the right construction technique. After this stage, we request and obtain clearance from the municipality's zoning and road construction division. The procedure lasts 18 days. We should see if whether the building is less or more than 10 meters from an existing road. If less than 10 meters, then we should contact the municipality's zoning and road construction division. The next stage is location clearance from the fire department. So our company should receive approval from the fire department, which is then considered by the design institute in developing the city planning documentation. The time to complete this procedure is 2 weeks. It is about $5 associated costs. The second step is requesting and obtaining technical conditions from electricity provider company. What for are necessary these technical conditions? Technical conditions are required for preparing the project design documentation and obtaining a building permit. Then we request and obtain technical conditions for water and industrial sewage. The agency, the competent authority is Upper Canal, Moldovan Authority. Here we should wait 2 weeks. 2 weeks in order to obtain technical conditions. Then the second step, we request and obtain technical conditions for sewage system. A separate specification is obtained from a Moldovan authority ex-Drupo, the Urban Roads and Bridges Management Authority on rainwater drainage. Then you request and obtain city planning guidelines, red lines from Design Institute of Moldova on engineering and research works. What else? At this stage, our company hires a licensed design institute to prepare a complete relevant set of city planning guidelines, red lines, which specify zoning regulations of the land plot. Then we obtain project clearance from the chief architect of the municipality. The chief architect has to approve the following sections of the project documentation: a master plan, situational plan, alignment plan, facades, color schemes, the project organization of construction works, and external engineering networks. Then the next stage is fire department. We request and obtain expertise clearance from the fire department. The fire department must approve the completed set of designs and drawings after the conditions have been assigned. We should visit the fire department to obtain the expertise consultation rather than go through the Department of Verification and Expertise. Then we request and obtain expertise of project documents at the State Service for Verification and Expertise of Projects in Construction. Here will be checked the technical conditions with all the utilities authorities. Then we request and obtain construction permit from the local city planning services agency. The application shall be accompanied by a set of documents established by law. This we can see these provisions in the law. The next stage, we notify the construction authorities and the State Construction Inspectorate about the start of construction. So at least 5 days before starting construction, we must notify the construction authorities in writing. The written notification is submitted in person and must be also filed with the State Construction Inspectorate no less than 30 days prior to the start of construction. If construction begins without prior written notification, certain sanctions would be applied against the company. And the construction period begins the day the permit is issued. And relevant authorities and ministries may require our company to provide valid proof of the legality of the start of construction work. Then we hire an external technical supervisor. The main point is that technical supervisor cannot be an employer, our employer. He should be an external technical supervisor. Then we request and connect to water and sewage. So we request the connection from the utilities. We extend the pipelines to the connection points. The inspector visits the site, approves the connection by sealing it, and opens the water shafts. Then health department. We request and obtain approval of construction works from health department. So after we finish the construction, we prepared a protocol of completion of construction works, and then fire department. We request and obtain approval of construction works from fire department. Then we request and obtain occupancy permit from State Construction Inspectorate. The main authority in charge of issuing the occupancy permit is the State Construction Inspectorate. The chief architect has the definitive word on the decision. The other authorities that must sign the occupancy permit are the Health Department, the Bureau of Technical Inventory, and the Fire Department, once again. Then, so we have some more stages. Then we need to hire a cadastral surveyor to prepare a report. We have to provide technical and cadastral plans of the building in order to be able to register the building at the Bureau of Technical Inventory. We have to hire an external cadastral surveyor to determine the boundary of real property on the ground. And in the end, we register our building at the Bureau of Technical Inventory. Seals are put on 6 copies of the blueprints, and our company is given 1 copy. It lasts 30 days. So it was the last stage of obtaining the construction permit. You can share your procedure. The competent authorities, the timeline, the costs, and for questions, please contact our email kishinev@gratanet.com.
So dear colleagues and clients, we have now reached the end of our conference, and once again, on behalf of GRATA International, I would like to take the opportunity to express my sincere gratitude to all participants who were here with us, and to the speakers for the time. And it is really interesting to know the legislation of our and regulation on construction markets of our colleagues, and we do share the same stages in most of the cases, right? In as I can see from Belarus experience, and we are sharing the same risks as it is mentioned by Ali in Turkey. It is worth to mention that it's actually, I forgot to mention that consortium might be also an option for foreign companies to proceed with construction activities in the region. So if Maxim, Ali, or whoever my colleagues want to add something before we finish, please welcome.
I just would like to thank you for your very nice moderation. You seem very experienced, frankly. Thank you for that. And for those who participated from the clients, any questions they may have, even after the presentation, even after this conference, we will be happy to respond.